I am Julie Silverbrook, Executive Director of the Constitutional Sources Project, or ConSource, and a proud alumna of the George Washington University. We are so glad that you all joined us today to mark the 227th anniversary of the signing of the United States Constitution. At ConSource, we celebrate the U.S. Constitution and our nation's history every day of the year through our digital library of historical constitutional materials at www.consource.org, as well as our legal and educational programs. But we do like to throw a party around Constitution Day and are thrilled to have Justice Ginsburg with us to celebrate the Constitution's 227th birthday. Justice Ginsburg and Dr. Maeva Marcus will discuss women and the Constitution during this afternoon's program. This is a timely topic, as both ConSource and the New York Historical Society are in the process of rolling out exciting new programs related to the role of women in our nation's history. ConSource, through our Women and the Constitution or Founding Mothers Project, and the New York Historical Society through its Women in a New Light exhibit. Both initiatives will bring together historical objects and documents, as well as digital materials and educational programs. If you're interested in learning more about these projects, please feel free to reach out to staff members from ConSource and the New York Historical Society after today's event. While we are on the topic of young women, I'd like to recognize two young women, one of whom is with us this afternoon, for winning the second annual ConSource Harlan Institute Virtual Supreme Court Competition for high school students. Michelle McAvoy and Uma Chatterjee won this year's competition, which focused on National Labor Relations Board v. Noel Canning by drafting an impressive appellate brief and prevailing in oral argument in front of a virtual panel of judges. I congratulate both of you on your achievement, and I'm so glad that Uma is here with us today to celebrate. There are a number of individuals who must be recognized and thanked for making today's program possible. First, I'd like to thank the terrific faculty and staff at the George Washington University Law School for agreeing to partner with us once again this year for our Capital City Constitution Day celebration. We think there's nice symmetry between last year's event with Justice Scalia and this year's event with Justice Ginsburg. I would also like to thank Dr. Maeva Marcus, who runs the Institute for Constitutional History at the New York Historical Society and is on the ConSource Board of Directors, as well as the GW Law faculty. Maeva is a force of nature. Without her efforts, today's event would not have been possible. I would also like to thank Kaplan Bar Review for generously supporting the live stream and recording of this afternoon's program. Before I introduce Chris Bracey, Senior Associate Dean of Academic Affairs at the George Washington University Law School, I'd like to review a few logistical notes for this afternoon's program. When you entered the auditorium, you should have received a 3x5 card. If you would like to pose a question to Justice Ginsburg, please write your question on this card as soon as possible and pass it to one of the ushers. During the Q&A portion of this afternoon's program, I will ask Justice Ginsburg a select number of questions. Photography is not permitted except for the last 2 minutes of the program. We will not permit photography during the first 2 minutes, which the opening suggested. In the last 2 minutes, and I will indicate this during the Q&A portion, when you can take pictures, we just ask that you not use flash during that time. And with that, I'd like to introduce Associate Dean Chris Bracey, who will in turn introduce Dr. Maeva Marcus and U.S. Supreme Court Justice Ginsburg. I hope you all have a happy early Constitution Day today and a wonderful Constitution Day on Wednesday, September 17th, which is the actual holiday. Thank you.
Good afternoon. On behalf of the George Washington University Law School, it gives me tremendous pleasure to welcome you all to this Constitution Day event. As someone who researches and teaches and writes about constitutional law, I spend a great deal of time thinking about the structure of government as defined by our Constitution and the individual rights protections set forth in this document which have proven such vital elements of our national identity. The Constitution is the foundation of what in many ways is our American civil religion. Constitution Day provides us with a collective opportunity to reflect upon the defining elements of the Constitution as well as the critical importance of constitutional decision-making in democratic life. We live in a time in which there is often serious disagreement over the important issues of race, freedom, privacy, sexual autonomy, and the list goes on and on. In these contested times, we need to be able to engage in meaningful constitutional conversations, such as the one we are so fortunate to have this afternoon. So I thank you for joining in this public conversation. It also gives me great pleasure to introduce the participants in today's conversation, Professor Maeva Marcus, and our honored and distinguished guest, the Honorable Ruth Bader Ginsburg, Associate Justice of the United States Supreme Court. Professor Marcus is a leading scholar in the field of constitutional studies. She received her PhD in history with distinction from Columbia University. Her dissertation, Truman and the Steel Seizure Case, was published by Columbia University Press and remains in print at the Duke University Press. As an editor of the documentary history of the Supreme Court of the United States from 1789 to 1800, Dr. Marcus has published 8 volumes along with many related articles on legal history. She currently serves as research professor of law at the George Washington University Law School and as director for the Institute for Constitutional History. She is also on the board of directors for ConSource. As for Justice Ginsburg, well, what can I say? She is a trailblazer. She is a champion of civil rights and individual liberties, and she's one of the most profoundly intellectual voices in the history of the Supreme Court. She was nominated to the Supreme Court by President Bill Clinton and took her seat in 1993 after having served 13 years as a judge on the United States Court of Appeals for the District of Columbia Circuit. She received her BA from Cornell University, attended my alma mater, Harvard Law School, and received her LLB from Columbia Law School. She served as law clerk to Honorable Edmund L. Palmieri, judge of the United States District Court for the Southern District of New York, and later as research associate and then associate director of the Columbia Law School Project on International Procedure. And prior to her first judicial appointment, she was also a law professor at both Rutgers University and Columbia University, as well as a fellow at the Center for Advanced Study in Behavioral Sciences in Stanford, California. She is a co-founder of the Women's Rights Project of the American Civil Liberties Union and served as the ACLU's General Counsel and on the National Board of Directors. Ladies and gentlemen, please join me in welcoming to the stage Professor Maeva Marcus and Justice Ruth Bader Ginsburg.
Well, I must thank you for that very warm welcome. I'm glad to be with you this afternoon.
And I'm delighted to be holding this conversation. And I think I can say for everyone in this audience that everyone is thrilled to be in the same room as the notorious RBG. In honor of Constitution Day, a little early, we want to talk about women and the Constitution. We know that the 1787 Constitution speaks of we the people and refers to the people as citizens or persons. It makes no mention of sex or race. The 14th Amendment introduces the word male when it specifies denying a male inhabitant the right to vote. It promises to any person, however, the equal protection of the laws. Not until the 19th Amendment, which was ratified in 1920 and stated that a citizen could not be denied the right to vote on account of sex, were women referred to in any way. But with no changes in the constitutional text, constitutional law has nonetheless transformed the world in which women today find themselves. I suspect that the young women in the audience have little idea how different life was for someone born in the first half of the 20th century, both of us. So I thought you might tell us, Justice Ginsburg, about some of the challenges facing women and you personally at the time.
When I attended law school, the class distribution was somewhat different than it is today. There were over 500 in my entering class at Harvard Law School. 9 of us were women. These were pre-Title VII days, and employers were totally upfront about saying, please don't send us any women. We don't want lady lawyers in our shop. Perhaps the best illustration I can give is the example of my dear colleague, Sandra Day O'Connor. She graduated in the 50s from Stanford Law School with very high grades. Not a single employer would give her a bid for a job. So Justice O'Connor said to a county attorney, take me on for 4 months. I will work without pay. And then at the end of the 4 months, if you think I'm worth it, you can add me to the payroll. The problem for women was getting that first job. Once they did, they were able to show that they performed at least as well as the men. So the second job was easier. Well, that's just a snapshot of what it was like in the law. There were so many occupational restrictions on women. The thought was that women were delicate and they needed to be protected. So, for example, Michigan had a law that said women cannot serve at a bar, cannot serve drinks, unless the woman's father or husband owns the establishment. Well, that's what the world was like. By the way, that case came to the Supreme Court, and in 1948, the court said it was okay to put the plaintiffs, they were a mother who owned a bar, her daughter, her bartender. That law of Michigan put those two women out of business. But the Supreme Court rationale was bars can be unpleasant places. There can be barroom brawls, and we must spare women from that. And nobody, at least nobody on the court at that time, pointed out that there was no restriction on women serving as waitresses in taverns. The waitress would be much closer to the rowdy drinkers. She wouldn't have a bar standing between her. But that's the way things once were, and happily no longer.
So I think everyone would like to know what in your personal life encouraged you to undertake the campaign to give women equal rights and obligations to men? Or why did women's rights become your passion?
Well, I was fantastically lucky to be born when I was and to be in the right place to help advance this movement for women's equality. Even the decade before, there were women and men, feminists, saying the same things in the 60s that we said in the 70s. But in the 60s, society and the court were not yet prepared to listen. So think of the case that was decided by the, quote, liberal Warren Court, Hoyt against Florida. Yeah, Gwendolyn Hoyt was on trial for the murder of her abusive, philandering husband. And her notion was that women on the jury might better understand her rage, her feeling of tremendous frustration when she took her young son's baseball bat and with all her might hit her husband over the head, ending their fight and precipitating the murder prosecution. Well, the Supreme Court said in 1961 it's all right not to put women on jury rolls, because after all, women are the center of home and family life. Gwendolyn Hoyt must have thought, but what about me? I thought the law was here to give me due process, to give me equal protection, but that part of the picture was not perceived by the court in 1961. Yet 10 years later, when Burger was the Chief Justice, the court decided for the first time in the history of the United States that a line drawn by the law on the basis of gender is unconstitutional.
Could we wait a second to get to that so we can sort of go before that, before we talk about the ACLU campaign and your participation in it? I wonder if we can talk about the status of women in constitutional law in the 1970s. I think the traditional common law doctrine of coverture was the one. If you don't know what coverture is, women had no rights of their own. They owed all their obligations to their husbands. And if you were a single woman, you still didn't have any rights. And they had no political relation to the state. And this was reflected in Supreme Court jurisprudence in cases like Bradwell
against Illinois, but before that, even in, I think, Minor against Happersett.
That's after, yeah.
Well, we can start with that one.
Yeah.
With the 14th Amendment on the books, which, as Maeva read, 14th Amendment says, nor shall any state deny any person the equal protection of the laws. And Virginia Minor thought, well, now I have this equal protection, so I must have the most basic right of citizenship, the right to vote. Well, the court told her, of course you are a person. We acknowledge that. But so too are children. And no one would suggest that children should have a right to vote. I call that the birds of a feather case. Women and children go together. Myra Bradwell's case was she was fully qualified to practice law, except for one thing. She was a woman. So the Illinois bar turned her down for admission, and the Supreme Court said that that was not a denial of due process, privileges, and immunity, equal protection. That's where the Supreme Court was. What was Bradwell was 1873?
Bradwell was 1873, and Minor was 1875.
Yeah.
But then, in 1908, the court took a bit of a turn in Muller v. Oregon.
Well, Muller v. Oregon was a test of the so-called protective labor laws. Muller was he was a laundry.
A baker, yeah?
No,
laundry?
Baker was Lochner.
Oh, right.
Muller
Yeah.
ran a laundry. And the state of Oregon had passed a law saying women couldn't work more than, I think it was 10 hours a day. Yeah. Muller liked his women to work 12 hours a day, and every day except Sunday. So he was charged with violating the law by not respecting the limitation of hours to 10. The Supreme Court upheld the Oregon law, although the protection was limited to women, not men. At the time, the social activists were pursuing what has been called a half-a-loaf approach. Maeva mentioned the baker. That was a case, Lochner v. New York, where New York had a limitation of hours for anyone who worked in bakeries. As the Supreme Court said, that violates the liberty to contract. If a baker wants to work 12 hours a day, so be it. So the half-a-loaf approach was, if we can't have protective laws for all workers, let's start with women and children. And that was the theory behind Muller v. Oregon. The case is famous for the lawyer who represented the state, who argued in favor of the protected legislation. It was a very great later justice of the Supreme Court, Louis D. Brandeis. And his brief was the first one that used economic and social data. In Muller, it was about the horrendous working conditions for women and the diseases that they suffered as a result. Well, the problem with Muller against Oregon, however, it was in 1908, over time, the 12-hour day shrinks to 8, the 6-day work week to 5. And then women began to notice that they are losing the opportunity for overtime, which pays double or time and a half. And these other protections that they had, like they can't work at night. Well, if you serve tables, you get the best tips at night, not in the afternoon. So the picture had so changed from horrendous working conditions for everyone, the women and children first approach, to a time when women began to understand that what was being protected was no longer their health and safety, but men's jobs from women's competition.
Right, I think that's right. So then in 1970, the Idaho Supreme Court denied Sally Reed the right to serve as executor of her son's estate, saying it did not constitute a denial of equal protection of the laws. And I think that's where your campaign begins, because you wrote the brief in that case. Would you like to talk?
Yeah, I should say first that when the women's movement came alive in the late 60s, not just in the United States, but really all over the world, the UN had declared International Women's Year. So I realized that it was possible for the Supreme Court and all the courts to catch up with the changes that already existed in society. And I had been a volunteer lawyer for the ACLU when Sally Reed's case came out. And a colleague at the ACLU read U.S. Law Week, read about what the Idaho Supreme Court had said, and concluded that this would be the turning point case. Why? It was a case that was heartrending. Sally Reed had a son. She and her husband divorced. When the son was young, the family court judge gave custody to Sally because the child was, quote, of tender years. And there is a mother preference for children of tender years. Then the boy reaches his teens. The father applies for custody, maintaining that now the boy needed to be prepared for a man's world. The court agreed with the father, much to the distress of the mother, who thought the father would be a bad influence on the son. Well, time went on, and the boy became increasingly more depressed. And one day, he took one of his father's many guns and committed suicide. So Sally Reed wanted to be appointed administrator of his estate, not for any economic reasons. There was a tiny bank account, there was a guitar, there were records, clothes, that's about it. But for sentimental reasons, she wanted to be in control. And the probate court judge said, Sally, my hands are tied by the law, which reads, as between persons equally entitled to administer a decedent's estate, males must be referred to females. As simple as that. So there was a heartrending life situation. There was a law that by the 1970s was totally arbitrary. And that moved the court unanimously, for the first time in the history of the court, to hold a restriction on women unconstitutional.
I know that that brief is very famous. It's known as the brief that laid out the entire argument for equal protection for women. And I know that you put the names of Pauli Murray and Dorothy Kenyon on the brief, though I know they didn't write it. Would you like to tell us why you did that?
Yes. I just said that it was impossible to achieve in the 60s what was achieved in the 70s. But there were women from Abigail Adams on who were urging the full citizenship stature of women. And two of those were on the ACLU board. One was Dorothy Kenyon. Her mission, her goal, was to get women to be able to serve on juries in every state in the Union. She had considerable success, but as Gwendolyn Hoyt's case shows, there was a way to go. And Pauli Murray was an African-American woman, a brilliant legal scholar, and she wrote an article called Jane Crow and the Law,
right,
which was very influential in setting up the targets that the ACLU Women's Rights Project would strike at. So I put their names on the Reed brief because they were by then quite elderly and no longer able to participate in developing the brief. But I wanted to recognize that we were standing on the shoulders of those brave women who were saying the same thing we were saying, but they were saying it at a time when society was not yet prepared to listen.
When you wrote the Reed brief, did you and your colleagues at the ACLU decide on a grand strategy to bring these cases forward, or did you just take them as they came in?
I have to say a combination of the two. None of the cases were test cases in the sense that we went out and tried to find a plaintiff that would fit a certain mold. They were all genuine life situations. I described Sally Reed. I should mention Stephen Wiesenfeld,
Yes.
a young man whose wife was about to give birth to their first child. The doctor came out and reported to Stephen, "You have a very healthy baby boy, but sadly, your wife died of an embolism." So Stephen vowed that he would work only part-time until his son, Jason, was in school full-time. And he thought he could do that because he had heard that Social Security benefits include benefits for a sole surviving parent, so the parent could care personally for the child. Stephen went to the Social Security office expecting to put in an application for what he thought were child and care benefits. But the person at the Social Security office told him, "I'm sorry, Mr. Wiesenfeld, but here's the statute. It says mother's benefits. These are not available to men." We wanted to show how gender lines in the law were unfair to everyone. Woman, and take Stephen Wiesenfeld's case, the discrimination began with the woman who paid the same Social Security taxes as the man, but didn't get the same protection for her family. Because the notion was men are the breadwinners, women, if they work, they're only pin money earners. Their principal job is to take care of the home and children. So in trying to break down that stereotype of breadwinning men, caregiving women, we had in mind the health of society, that no one, male or female, should be held back from an opportunity simply because she is female or he is male. And that Wiesenfeld's case illustrated the pernicious effect of that rigid line, this vision of the world as divided between the stay-at-home women and the outside making bread man. That's what we sought to break down, and there were hundreds of laws on the federal law books, on the law books of every state that replicated that distinction, that classifying women as stay-at-home caregivers, men as out in the world breadwinners.
And I know you argued 6 cases before the Supreme Court, and I think you lost only 1. And several of the parties whom you represented were men. You represented another, not Gwendolyn Hoyt was earlier, but a murderer, right?
Yeah. This was in the state of Missouri. Missouri had an opt-out system for jury service. In Kansas City, Missouri, the jury clerk would send out notices, and it would have in big letters, "If you are a woman, you are not required to serve. If you don't want to serve, check off here." And if the woman didn't return the card, then it was automatically assumed that she did not want to be on the jury rolls. There was a very intelligent public defender in Kansas City, and in every case, he raised the objection that his client would not have the opportunity for a jury of his peers because half the population was not there. The Supreme Court got the message. I think Duran against Missouri was 1978.
Mm-hmm. 79. 79.
79. It was argued in 78 and decided in 79, yeah. So there were about 150 cases backed up behind Durans, which meant that there would have to be 150 new trials or plea bargains to deal with those people. I like the story of Missouri finally changing and calling women and men to jury service on the same basis, because it shows how someone with goodwill and understanding can make things better. So we contrast Kansas City, where very few women served on juries, with St. Louis. St. Louis had a jury clerk that sent the same notices to everyone. And he didn't say, if you're a woman, you need not serve. If a woman asked for the exemption, she would, of course, get it. But because it wasn't advertised, most women didn't. And the juries in St. Louis were about 50-50, male and female, which meant that the prosecutors in St. Louis had no problem, but in Kansas City did.
Well, I want to talk about another case, if you do, which I think you probably wanted to argue and never got to, Susan Struck, Captain Struck.
Yeah. Captain Struck was in the Air Force. She was serving in Vietnam when she became pregnant. Now, these are pre-Roe v. Wade days. The base commander told Captain Struck, you have a choice. You can get an abortion, which we will provide for you on base. We do that for women in service and dependents of men in service. But if you do not want to terminate the pregnancy, you will be immediately discharged. Susan Struck told the commander, I cannot have an abortion. I am Roman Catholic, but I will use only my accumulated leave time for the birth, and I made arrangements to have my child surrendered for adoption immediately after her birth. A rule was a rule, and Susan's plea did no good. And she was, as an intelligent woman, really puzzled by the legal situation, because at that time there were many men in service who were depressed, who used drugs or alcohol to alleviate their depression. And the rule in the service was, if you report yourself as a drug addict, an alcoholic, we will keep you in service and we'll put you in a rehabilitation program. So Susan Struck was looking at the men who were undergoing months and months of rehabilitation, and she said, it would cost the FISC a lot less, the 2 weeks that I'll take off to give birth to a child. Well, Susan was well represented by ACLU lawyers when she was sent back to the States to be discharged. They got her discharged, stayed month by month, which meant she was always in service, fighting to stay in rather than being discharged and fighting to get back in. Anyway, she lost in the district court, lost in the Ninth Circuit, but it was a 2-1 decision with an excellent dissent. The Supreme Court granted review, and at that point, the Solicitor General called in the Air Force brass and said, this rule, if you're pregnant, you're out, does not make sense. Immediately waived Captain Struck's discharge and then changed the regulation prospectively, which the Air Force leaders did. And then, of course, the Solicitor General moved to have the case dismissed as moot. But my notion was, if the first reproductive freedom case to get to the court had not been Roe v. Wade, which was a woman's plea for access to an abortion, if instead, if it was a woman saying, I chose birth, but my government is telling me that that comes at the price of my career. If they could have had that as their first pro-choice case,
Yeah.
I think maybe the development would have been different thereafter.
I know. Life has many surprises, and we can't count on what happens. I think the 70s were probably an opportune time to challenge established equal protection, because you had the passage of the Civil Rights Act, Title VII. You had the feminist movement. Betty Friedan's Feminine Mystique was published. And most of all, the Equal Rights Amendment. Do you think that the agitation over the Equal Rights Amendment affected the court at all?
Well, perhaps I should say to this audience, I may not know the history of the Equal Rights Amendment. It was first introduced in Congress in 1923 by the Women's Party.
Right.
And that party was made up of suffragists who wouldn't settle for the vote. Their position was women should have equal citizenship stature in every domain. So every year they introduced the Equal Rights Amendment, and in the early 70s, that effort really took on steam.
Yeah.
So throughout the 70s, there was an attempt. At first, many states came on board, but then when there were only 3 left, things slowed down, and the pendulum swung the other way. But the Supreme Court, I think the justices were of mixed minds about the significance of the Equal Rights Amendment being in the political hopper. Some thought it showed that the political branches of government were on board for recognizing women's equal citizenship stature, so the court could be brave. Others thought, why should the court enter this fray when it's about to be settled in the political process? The Equal Rights Amendment is on the books, then we won't have any reservations at all about striking out these gender-based classifications. So some thought it was a go-ahead sign, it was a green light. Others thought it was a yellow light, go slow. Let's wait till the Equal Rights Amendment is on the books.
Do you think it should still be ratified?
Maeva, I do for this reason. I think probably as the cases have developed, statutes like Title VII and Title IX have given us almost what the Equal Rights Amendment would have. But if you pick up any constitution written since 1950, any place in the world, there will be, along in the Charter of Human Rights, a provision on the equal citizenship stature of men and women. It's not in our Constitution.
Right.
So if my granddaughters look at our Constitution and say, Bobby, you're always talking about giving women and men
Right.
equal
Yeah.
opportunity to be whatever they want to be. But where does it say that in this Constitution? So I would like to see a statement of women's full citizenship in the Constitution on a par with our right to freedom of speech, freedom of religion. It's a basic tenet of our society. So for that reason, it belongs in this Constitution, as it is, as I just said, in all of the post-1950 constitutions.
Well, I have a question. In 1992, when you were still a Court of Appeals judge, the Supreme Court decided Planned Parenthood of Pennsylvania v. Casey. It's a case in which the court effectively declared an end to coverture by saying women do not lose their constitutionally protected liberty when they marry. When you joined the court, the positive trajectory of equality for women continued. For example, your opinion and the court's decision in U.S. v. Virginia, the VMI case. But the composition of the court has changed. And in more recent years, you've been the author of some forceful dissents. Gonzalez v. Carhart, Burwell v. Hobby Lobby, where the majority, among other things, has been unfaithful, you say, to the principles of Casey. Would you like to say a word or two, sort of in conclusion, before we open it to questions?
As long as one lives, one can learn. And I'm thinking, my best example of that is my old chief. Except for Stephen Weisenfeld's case, then Justice Rehnquist was on the dissent side in every case in which I prevailed. And yet, in his last years on the court, he wrote the decision upholding the Family Medical and Leave Act, which is a piece of legislation designed with the woman worker in mind. What does she really need to be able to do her job? Well, she needs to take time off if her child is sick, if her spouse is sick, her elderly parent. Chief Justice Rehnquist wrote such an excellent opinion upholding that law against constitutional challenge that when I brought it home and showed it to my husband, he said, "Ruth, did you write that?"
Yeah.
So that's my example. As long as we live, we can learn. And this is just my guess, but I attributed that learning as much to Chief Justice Rehnquist having had granddaughters that he loved dearly and beginning to think of what he would like the world to be for them.
For them.
Yes.
Yeah, well, that is a very pleasant thought. And now we want to open the session to questions from the audience, and I think Julie Silverbrook has been collecting them.
Thank you. Yes, we do have a number of audience questions, and I'm going to start us off with a Constitution Day themed question, which is, if you have one, what is your favorite constitutional provision?
Well, you heard it. It's the 14th Amendment provision, nor shall any state deny to any person the equal protection of the laws. Let me put a postscript about that. The word equal does not appear in the original Constitution, and it does not appear in the Bill of Rights. Why? I think all of you know. Because there was a stain on our record. The Constitution preserved slavery, so people know about the preservation of the slave trade till 1808. What I like to point out, because when I talk to school groups, I discover they sometimes don't know. The worst provision in the original Constitution is in Article 4, and it is the Fugitive Slave Clause.
Yes.
So that's the original Constitution. Then we get Brown v. Board. The lead case is from Kansas, and Kansas is not allowed to deny people the equal protection on the basis of race. There was also a case involving D.C. schools. And D.C. is not a state, sadly in my view, but it is not. So where does the Supreme Court get the authority to say that our nation's capital cannot have any remnant of apartheid? They cannot separate children on the basis of race. The court then did something neat. They looked back to the Fifth Amendment that has the due process clause. Due process clause is repeated in the 14th. Due process in the original Constitution restricted only the federal government. 14th Amendment, it restricts the states as well. So they read an equal protection component into the due process clause of the Fifth Amendment. And in Bowling v. Sharp, the court said D.C. schools cannot be separated by race.
Our next audience question is, what was the most difficult case you've decided?
I should say that the court has no easy cases in this sense that we generally will not take a case where other courts agree on what the answer is. So if a case comes to us, much more likely than not, there will be conflicting opinions in federal circuit courts, maybe the state Supreme Court. So good minds have reached different conclusions on that hard problem. That's why every case that we have is challenging. But I will say, not necessarily in terms of the legal intricacy of the question. The hardest cases for me fall into a category, and those are the death penalty cases. I was blessed sitting on the D.C. Circuit for 13 years with no death penalty in the district, so this was all new to me. And as you know, Maeva, the court's jurisprudence in this area is very dense. But it wasn't the difficulty of the jurisprudence as much as it was being part of a process that determined life or death. So on my very first week on the court until this very day, those cases are most troubling.
Our next audience question has a bit of a introduction. It says, the opinions of John and Thurgood Marshall have become a part of our shared national dialogue. Which of your opinions was written for the ages?
I'm not thinking so much about the ages as I am. So the court got it wrong. How can it be fixed? One way is Lilly Ledbetter's case as an example. Lilly Ledbetter was told that she sued too late. It would have to be very long talk for me to explain why the court's majority decision made no sense. I did explain it in my dissent.
Yes.
And in the last line was, the ball is now in Congress's court to correct the error into which my colleagues have fallen. And in very rapid time, Congress passed the Lilly Ledbetter Fair Pay Act. If it's a constitutional decision that the court gets wrong, then you can't appeal to the legislature. You are appealing to a future court. And that has come up time and again in U.S. history. One of the best examples, Justices Holmes and Brandeis, around the time of the First World War, had a number of outstanding free speech decisions, reminding the government that in this country we should have the right to think, speak, and write without Big Brother government telling us what's correct. to think or speak or write. Those were dissents for 2 justices, and today all those dissents are the law of the land. So that is my hope when the court makes a constitutional ruling that I think is profoundly misguided. You mentioned Hobby Lobby. Hobby Lobby is something that Congress would be able to fix, except that, sadly, the current Congress doesn't pass anything.
So I think Maeva's going to exercise moderator's prerogative and ask the last question.
Well, it's a soft question, but I was just curious as to how life on the court has changed with the addition of more women.
How was it in the beginning? So I was the second woman. Justice O'Connor was on the court all alone for 12 years. Every year that we served together, one lawyer or another called me Justice O'Connor. I mean, they knew there was a woman on the court. Her name was Justice O'Connor. And even though we don't look alike, we don't talk alike, that's the way it was. Then when Justice O'Connor retired, was it 2006? Yeah. So then I was all alone. What bothered me was the perception of the public coming into our courtroom, seeing 8 men and then this rather small woman. So, along come Justices Sotomayor and Kagan, and now because of my seniority, I sit toward the middle of the bench. And Justice Kagan is on my left, Justice Sotomayor on my right. And I must tell you, you know, if you ever visited the court recently, those women are not shrinking violets. They are very active in the dialogue between the lawyers and the justices. Since I have had their good company, no one has called me Justice Sotomayor or Justice Kagan. It looks like we're there to stay, 1/3 of the court, no longer one at a time curiosities.
Well, I hope so. I thank you very, very much for being here. It's like, come,